Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as your Law Intellect. Thank you all so much for joining me. First off, thank you so much, Katna Williams, for becoming a member. I appreciate your support. A Soft Place 4370. Thank you for being a member for 14 months. I appreciate you. You guys heard me right. You heard me right. We were covering the Cardi B trial with Emani Ellis, who accused Cardi B of an assault and battery of which she lost, and she lost terribly. However, since the trial has ended, there has been a lot of paperwork that has been filed to this docket. As we talked about on the previous video, one of the issues is that Emani Ellis's attorney was accused of misconduct, and Cardi B's attorney decided, I'm not going to let you get away with this. I want to file a motion to show cause as to why you shouldn't be held in contempt for this alleged misconduct. We also went over the response from the attorney, and in the response, the attorney basically said, listen, I'm broke and I want to move on, okay? He's already threatened me to call the bar. I feel like that's against rules of professional responsibility by trying to use that as some type of tool or leverage. He felt like he was mistreated. He said that he doesn't have the money. He's already financially struggling. He came out of money, obviously, for this case because it was a civil case that was on contingency, meaning that he only would have gotten paid if he would have won, which he did not. So that means that that expensive expert had to be paid for, regardless win, lose, or draw. Before that expert took that stand, he took that check. Okay. And so he said, well, I want to be over with this case. I just want to be done. Can we just move on? I can't even afford to go research and respond to this. I just need to move on. And was asking the court to just let it go. You go your way. We shake hands. You go your way. I go my way. Just leave me alone. And one of the things that was very interesting is I recall the press conference, and we talked about it, where Emani Ellis said that they were going to appeal. And I was like, appeal what? What exactly are we appealing here? I don't, could you please point me to the statute, to like what exactly happened that you feel like an appeal is warranted? So when he said he wanted to go away and they go away, he mentioned the press conference of which Cardi B's attorney said we just want to move on. So he used that as support that everybody wants to move on. But again, at the press conference, he said he wasn't moving on because he was going to file an appeal. Well, while all of this is going on yesterday or the day before, Emani Ellis's attorney has filed a motion for a new trial. Yep. Is requesting, saying that there were some type of issues that happened in the trial that affected the outcome. And you guys are going to look at these issues and say, what? What are we talking about? So that is your intro of what we're going to talk about today. So in the interim, if you guys could be so kind as to hit the like button and subscribe to the channel if you have not subscribed already. And again, thank you to the new members. I appreciate you. I'm going to just pull it up. No need to procrastinate. We just pull it up. So this is the motion for a new trial. And honestly, I really thought she filed this pro se at first. I was like, well, since he said he doesn't have money, he said that he wants this to go away. Maybe he's told her that any post verdict paperwork she has to do it on her own, which some people do. The retainers will specifically say, I am only covering you up to trial and verdict. Anything post conviction, aside from me being able to request attorney fees from the other side, or vice versa, we're done with it. Same thing from a criminal aspect. Typically, you'll say this retainer does not cover any appellate work. Although in some situations, when you're in federal court, when you sign on to certain cases, you also are signing up to appeal unless the court says otherwise. But generally speaking, you can put it in your retainer, and most people do. Listen, past this hoorah that we have going on, we're not doing. You're gonna have to either rehire me and pay me some more money to do this, or whatever. So when I first saw this, I was like, oh, maybe she's doing it pro se. And I was saying that based off the conversation of, I want to go my way and I want you to go your way. Well, no, this attorney looks like he is the one that has filed this motion for a new trial. What up, though, Arthur Von Renee? Good to see you. And this is the document that was filed. Miss Emani must have gotten a settlement in advance. You know what? So interesting enough, this is just a little fact that probably has nothing to do with this case, or it may. There are people who provide loans against settlements or verdicts. So, for instance, a client gets in an accident, they say that they can't work. They're suing the insurance company because the insurance company hasn't just agreed to pay them for their injuries. There are companies like investment companies of which they loan out money against your verdicts. So, or against your settlements. So they'll send a document over. And I'm not saying this is what happened in this case. I'm just giving you guys a little bit of information that this does happen. They send like a document over, all the information about your case, and you kind of value your case. And then they'll say, okay, well, we'll loan them $2,000 based off of what you said, but then you got to pay us $4,000. Like it's a crazy percentage on which you have to pay back. Typically, we'll try to negotiate it if we can't talk our clients out of doing it in the first place. But there are some clients that get into situations where they really cannot pay their bills. And so because they can't pay their bills, they do try to, you can't talk them out of it. Shoot, I can't pay for all our bills, me and my clients. So they do that. But yeah, I just thought I'd give that little tidbit because some people may or may not know that actually does happen. Thank you so much, Miss J, for the super sticker. I appreciate it. That is so kind of you. Let's get to this document because I had to read it twice, and it's not very long. So it has, again, Emani Ellis versus Belcalis, and it has the motion for new trial, memorandum of points and authorities in support of motion for new trial, and a declaration of Ron Rosen Janfasa Esquire. And this was filed. They're asking for a hearing on December 5th, 2025. Because what they do in California, and again, I don't practice there, but I've looked at enough documents and been in their court a few times. They sign you like IDs when you call and I guess get whatever time for you to be able to give your to provide a hearing date for you to go in. So let's get into this. Is just the motion part, and then we'll get in the brief part. This motion is made based upon this motion, the declaration of Ron A. Rosen Janfasa, the memorandum of points and authorities, the pleadings, documents, records, and the files in this action, documentary and video evidence as may be presented at the hearing, as well as any witnesses who will testify. This motion for a new trial will be made upon the following grounds pursuant to the Code of Civil Procedures, Section 657. So these are the grounds that they are alleging. Yes, this is the same person that wanted to just go your way and let this be done because he's so stressed out. He already got to deal with the bar. He got to hire an attorney. This is the same person that just filed this motion for a new trial. I'm not, something ain't, yeah. So the first one is irregularity in the proceedings of the court, jury, or adverse party, or any order of the court or abuse of discretion by which either party was prevented from having a fair trial. The second reason is accident or surprise, which ordinary prudence could not have guarded against. The third reasoning is insufficiency of the evidence to justify the verdict of their decision, or the verdict or other decision is against law. And four is error in law occurring at the trial and exerted by the party making the application. Error in law occurring in the trial and accepted to by the party making the application. I'm like, what does that even mean? Okay, I read that wrong. The motion shall be made upon the minutes of the court and as to paragraph 1, 2, 3, and 4 above. Plaintiff Emani Ellis prays that this honorable court grant the motion for the new trial. As you see, this is the attorney. Okay. So let's get into the rationale behind why he feels a motion is warranted. So plaintiff Emani Ellis was assaulted and battered by defendant Belcalis Almanzar on February 24, 2018. The parties proceeded to trial before a jury of 12 people, which lasted from August 25, 2025 to September 2nd, 2025. Defendant obtained a defense verdict. You got no cause. That's what happened. Plaintiff's counsel respectfully applies to the court for a new trial for multiple reasons which affected the outcome of this case. First, there was a trial misconduct by defense counsel Peter Anderson Esquire, who should be held in contempt for his violations of court orders and the California Rules of Professional Responsibility. Defense counsel violated California Rules of Professional Responsibility, Rule 3.10, threatening criminal, administrative, or disciplinary charges. Defense counsel threatened plaintiff's counsel several times during the pendency of this case, as well as the course of the trial, that he would report him to the State Bar of California. Defense counsel violated California Rules of Professional Responsibility, Rule 3.10. In my last video where I talked about the response to the order to show cause, or the motion for an order to show cause, this was mentioned by this attorney at that point, and there was an email that he attached as evidence, and I didn't really see what he was saying in the email. So I'm going to put the video at the end of this video so you guys can watch it and see what I'm talking about. So he did attach one email of which he is alleging there was a threat of some sort of contacting the bar on him. So he's saying that was misconduct by Cardi's attorney. The granting of a new trial is appropriate because the record establishes that defense counsel threatened plaintiff counsel to obtain an advantage in a civil matter both before and during the trial, lastly on August 27, 2025 at the courthouse. Now, this is the second reason. And this is why you guys was looking at my title like, girl, what? But I got it from this document. This is what counsel says. He alleges, he says, second, defense counsel Peter Anderson, clearly they're not friends. Apparently they're not cool like that. It's what it sounds like. So second, defense counsel Peter Anderson also physically intervened when plaintiff's counsel was speaking with Dr. Fink on August 27, 2025 at the courthouse, which amounted to an assault and battery. Unfortunately, the jury was present in the hallway. Let me blow this up because I don't want you guys to think I'm making this up. Let me read this over again. You guys read along with me like you did in class. I'm going to read it loud. You guys read it silently to yourselves. Second, defense counsel Peter Anderson Esquire also physically intervened when plaintiff's counsel was speaking with Dr. Fink on August 27, 2025 at the courthouse, which amounted to an assault and battery. Unfortunately, the jury was present in the hallway waiting to enter the courthouse waiting to enter the courtroom during this interaction. This is not the only time that defense counsel has unlawfully made contact with plaintiff's counsel against his wishes. Did y'all see that? He said that he intervened and it amounted to an assault and a battery. Thank you so much, Miss J. I appreciate the super chat. Let's go on. Third, you guys know about the pen incident because they talked about it. I mean, he brought it to the court's attention while the trial was still happening. Third, to add insult to injury, on September 2nd, 2025, defendant threw a pen at a man outside the Alhambra courthouse in California. I know I probably butchered that name, but yeah. The incident happened while she was on a lunch break during the trial. The incident caused another individual to get pushed and injured. It was also completely unlawful and disrespectful for defendant to injure others during the trial on the courthouse property, which she did on September 2nd, 2025. Additional time is needed to determine if defendant's actions of throwing a pen at a man outside the courthouse were witnessed by the jury. Plaintiff requests additional time to investigate this further. Jurors would be intimidated if they have viewed this type of conduct. First of all, I would argue that it would be the opposite. If they were outside, from my understanding, there was a pen thrown at the ground and nobody was hit with the pen. But aside from that, I would surmise that a juror would say, you know what? If she throwing pens at people, if they saw it, it would have been more beneficial to them because they would have said, you know what? She do got a little bit of temper and she may be doing A, B, C, D, and E. But he's trying to suggest if they saw this incident, then they may have been intimidated by Cardi B, which I guess he would equate to maybe their verdict was rendered out of fear. Kelly, Forrest Forever said, why is he lying? Nobody got hurt. Alhambra. Is that right? Alhambra. You said it's a reach. You said the jurors were in deliberation at that time. I don't think the jurors will come out the same side. That's what I'm saying. I feel like that would be, if they knew about it, I don't think that would be beneficial to Cardi B. I think it would go like, maybe I shouldn't give her they wouldn't discuss it because you're not supposed to consider outside information. The only thing you're supposed to consider is the evidence before you. So, and they're not supposed to consider it either way if they knew or didn't. But I'm just saying, if they just happen to be outside trying to get something off the food truck when it happened, then I would say that in any person's mind, you would be thinking more so, I don't know, she out here flipping out on somebody else, then perhaps maybe. I'm saying that would be more of what it would lean towards, but they're trying to use, yes, Pengate. Yes, Pengates. Yes. You said that pen didn't hurt no one. Listen. Yes. Reach. Trying to find. I just don't understand how you said you want to let this go. You can't afford it. You stressed out. This is causing anxiety. You worried about losing your license. All you got. You want to be a judge someday, and this is affecting, everything, because now you got to deal with the bar. Even though I didn't really see a bar complaint, I didn't see him attach one. But nonetheless, he says all of this stuff to avoid these potential sanctions, and then you turn around and file a motion for a new trial. So what if the court grants it? How are you? You just said you can't afford it. So if the court were to grant it, this is a real big hypothetical. If the court were to grant a new trial, how you paying for it? You said you didn't have any money. That's what you said. Slim Bone said he wants to be a judge, and it sounded like he was asking for a reference. I guess Queen Shadina, he said he liked. Maybe he forgets what he's writing before this. I don't know, but this is just a little odd to me. Why wouldn't he be concerned about her answering questions in front of the jurors if he claimed they could have been outside? The world seen this case. It's her album cover. I don't get that one. I don't get that question. Jam said he saw all the money he was out, so he want to double it, bet, and let it ride. Kelly said, right, didn't he use the argument that both parties were going their separate ways? Yeah, when he was responding, he said he can't even afford to really formalistically respond to it. He just telling the judge, he pulled up the different comments, said he didn't do it on purpose. It was not intentional, and he made some mistakes. He's not, quote, they're saying he's seasoned, but he's only done a handful of trials. He's done trials as co-counsel with other people, but he's only done a handful of trials. Like, he gave all of these different reasonings why he shouldn't be sanctioned, and then said, well, he said in front of the world he was going to let this go, so how was he not letting this whole trial go if blah 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 blah? But then you asking for a new trial? Like, this is baffling. Okay, let's go on. So they want time to talk to the jury, I guess, and see if they saw the pen incident. This is not defendant's first time injuring others. So now he's getting to the mic throw from the lawsuit in Las Vegas. In July 2023, defendant physically threw a microphone at a concert going at Dre's Beach Club in Las Vegas, Nevada, who was injured. Defendant clearly feels she is above the law and can do whatever she wishes to do. Plaintiff should be allowed a fair trial before a jury of 12. Granting plaintiff a new trial will provide her with the closure she needs. Girl, you might want to just talk to your therapist, because this is not it. This is not what the courts are for. A new trial will give her the closure she needs. I thought you guys were proud of her, that she stood 10 toes down and she doesn't regret it, and she's glad she got her story out, and she wouldn't change anything. And she, I thought that's what you guys were saying at this good press conference. Let me pull up this press conference, because let's see. See if I can find it. Let's see what happened. But was that just her? I want to see if the one with Emani is on it, because we heard what Cardi said. Let me see. Emani Ellis. We got to do a little bit of research here, because this is all right. Hold on. I don't want to use ET. They might flag me or something. I might just play it. Maybe I'll just play it.
Not at all. I don't think that it reflects the truth, but I'm not disappointed. We know that the justice system is sometimes flawed, and unfortunately, that was the case for me. Like I said, I still stand firm on my position. I still stand firm on my attorney. I think we fought a good fight, but like I said, more importantly, it's about accountability. I had my day in court. I showed up. I held my head high, and I can walk away and say that I showed up, and she had to look me in the eye. I had to look her in the eye, and we did our best.
Are you sorry you brought the case in retrospect?
Not at all. Not at all.
She said that she would refuse to countersue in this case. She said that if anybody else, brings a case, this is her words, that's frivolous, she called it, she would be countersuing, not to basically mess with her. What do you think about that?
This is for me?
Yeah.
Well, my statement is, obviously, you never know what a jury is going to do. You could try a case in different courts with different juries, and you'll have 10 different outcomes. You just never really know what a jury is going to do. We did our best to present the facts that we needed to present to the jury, and we obviously have a right to appeal, and our intention is to appeal.
You're going to appeal?
How do you feel about
Yes.
how the defendant conducted herself in court?
I thought it was totally unprofessional. I think it showed value to her character, the type of person that she is. A lot of her body language, her body gestures, her facial expressions, her disrespect for the court, I think speaks to who she is. I think we saw how I conducted myself during this trial, and I think that speaks volume.
Sir, could you say and spell your first name and last name?
Sure. My name is Ron Rosenjan-Faza. I'm the attorney for the plaintiff. I've had this case for a number of years. I did take it over from another lawyer, and we put it together as best we could with what we had to work with. I disagree with the verdict. As you know, you can see from Cardi B, she has a history of doing these things. Even today in the courthouse, right in where I'm standing in this area, she threw something at one of you. And I think that's just, very poor judgment on her part to go ahead and do something like that here in the courthouse. This is a court. You don't do this. It's wrong. And she really, made a fool of herself, in my opinion.
With the unanimous verdict, what is the basis for an appeal? Would it be a factual error, something that the judge did wrong? What would the basis be for an appeal?
Well, there's many different things that occurred. I can't really get into the details now. That would be for the appellate attorney that I work with, who's going to be handling that with me, and we will decide how we're going to handle it.
I'm going to law school.
Hey, congratulations.
Thank you. I
Did this
appreciate that.
case prompt you to decide to go to law school?
I had already had plans on going to law school, but I think during this case, it kind of amplified a lot of those dreams.
Do you feel like you've been painted in a bad light in the public?
I think from the defendant, yes. But that's what she's going to do. She's going to make me seem like a bad person. I know who I am. I know the things that I've accomplished. So that's all that matters to me.
You started out as a fan of her music. Are you still a fan today?
No,
Will you be listening to her new album that drops in 6 days? You keep saying.
not at all.
Ms. Ellis, Cardi did ask that the public please leave you alone, not slander you, say things behind your back on social media. Does that mean anything to you?
That's news to me. She's never told me that. She's never even offered me an apology. So I'm not sure.
Why would she offer you an apology and she just won the trial? But anyways, nonetheless, all Cardi said was don't come after her, don't come after her family, because the fans start tripping. Some of these people are very, very loyal. And so she said that. For her to say she didn't offer me an apology, why would she apologize and she denied that she had done anything wrong to you, lady? Like, what are we doing? Where am I at right now? So anyway, the point was, you said let me get back to this. Let's get back to this. Okay. Refusal to grant plaintiff's request for judicial notice was an error of law. Another thing I wanted to say as well before I get to that point is that there were motion in limines that were this attorney, and I told you all, to me, I felt like his strategy was to bolster his client's credibility by going to all her prior bad acts. So her attorneys, as they should, they filed motion in limines to exclude any information related to any allegations against her, any past alleged assaultive behavior, the whole gang, whether she was in gangs and all of that stuff was eliminated, because what a lot of people, what you're trying to do in a backdoor way is almost say, if you did that, you probably did this. And so it's more prejudicial than it is probative. So the court didn't allow it. That's why Cardi B's attorney was mad when the first question was about gang affiliations, because it was like, we did a whole motion in limine. Why would you bring that up? And you can't unring a bell. Like, if a jury hears stuff, you can say, jury disregard and strike. And if Cardi would have lost this trial, she probably would have brought that up, that this was cause for, almost cause for a new trial, because it could have affected the jury by you bringing that up. So that is why it feels like he's doing the exact same thing in this motion for a new trial, where he's bringing up a lawsuit that was filed, of which Cardi B has not even entered an appearance yet. From watching the docket, it looks like Dre's the club, they filed a motion to dismiss in that case. However, we don't see Cardi. I think Cardi was served, but we haven't seen a response yet. So because we haven't even seen a response yet, him bringing this up is just like, she's not even in that case. It's just an allegation like everything else. Your client was an allegation. You could stand firm and say that you believe your client. That's fine, but the jury didn't. So as far as this jury, she is not liable for hitting your client. They did not believe your client. When it came to the credibility, that was a fact question for the jury, and the jury came and made their determination. And as much as possible, the court is going to try to honor the jury's verdict, unless it's just so far off to the left, or it was such some issues that occurred that, in the interest of justice, there needs to be an overturning or a new trial or setting aside the verdict. But I don't see that at all in this case. So anyway, let's get into point 2. Refusal to grant plaintiff's request for judicial notice was an error in law. So the defendant testified about the length of her nails in a photograph presented to the jury. Defendant testified that the picture was taken on February 24th, 2018, and that the 67th National Basketball Association All-Star Game was on February 24th, 2018, which was untruthful and inaccurate. Plaintiff filed a request for judicial notice that the 67th National Basketball Association All-Star Game took place on February 18, 2018. The jury should have been advised of the correct date of the 67th National Basketball Association All-Star Game. This was denied, which was an error in law. I don't know whether it was the 24th or what. I mean, they're trying to say that her nails, I guess, weren't as this, and they didn't believe your client. It don't matter if her nails was long, short, skinny, pointy, square, oval. They didn't believe your client. So now you're reaching, saying that she said this picture was taken on the 24th at the All-Star Game, but the All-Star Game took place February 18th. It wasn't the 24th. So somehow they feel like the court not taking judicial notice of that date was some form of error. That's what you said those pictures of her scar did it for you. What scar are you referring to, huh? Is that the scar? They said she had makeup on, so we wouldn't be able to see. We wouldn't be able to see the scar anyway. That's what the. All right. The next allegation, the third argument is the jury verdict was unsupported by the evidence due to the allowance of non-disclosed witnesses. So he says it is well established that when ruling on motion for a new trial, alleging the evidence at trial was insufficient to support the verdict, the trial court evaluates the evidence as a whole and weighs the evidence sitting as an independent trial of fact. Plaintiff filed in opposition to the introduction of the name of her own doctor, David Fink, MD, in written discovery, who she could have surely produced. Defendant could have also contacted her own doctor's office to obtain the name of his employee, Miss Tierra Malcolm. Dr. Fink's identity was known to defendant since she booked a medical appointment with her doctor. The law is clear that the court is empowered to exclude evidence and witnesses not otherwise disclosed in response to appropriate discovery. So he's saying when he sent her interrogatories and said, please identify the name of your doctor, perhaps I guess that you saw on that day, the receptionist, anybody, any employee, agent, supervisor, manager, physician, technician, nurse, phlebotomist, whoever works there, please disclose their names that treated, worked on, did any type of procedures on Cardi B. Apparently, they're alleging in that question, in the interrogatory, they did not list David Fink. So he's saying he only knew about who David Fink was because Dr. Fink's identity was known to defendant since she booked a medical appointment with her doctor. And so they feel like they didn't get it when they asked for it, but they got it. That's not really how that works, though. If you have the identity, whether you get it from whatever, you can't say you didn't know who it was. If he was on the witness list, then you that's what the witness list is for. Typically, you'll do some preliminary witness list or what we call initial disclosures, and you'll put all the witnesses you know at the time, and then you do a more confirmed witness list during during the course of litigation. They'll ask for your witness list, and it's done right before or in the middle of discovery. So most of the information that you haven't disclosed already, if you add anybody new, they can go ahead and they can ask questions about those people, or they can ask to do depositions, and then you'll do your final witness list. Most courts will ask you for your final witness list, because when you do your initial witness list, we throw everything against the wall and see what sticks. So it might be 100 witnesses because we don't want you to try to pull one of these and say it wasn't disclosed. But ultimately, you list 10 orthopedic doctors, 10 neurologists, 10 different accident reconstructionists, 10 nurses. Like you oversaturated because you don't want to act like, them coming back saying it wasn't disclosed. But then as time goes on, you narrow it down to one doctor, 2 nurses, one accident like that's how it goes. So he's trying to say it was not disclosed initially when the identity wasn't disclosed, I guess, when he asked in his interrogatory. So he wanted that person excluded. This honorable court had the power to exclude these 2 witnesses as defendant intentionally hid their identity. So, of course, the doctor and that nurse that was there was very important to Cardi's trial, to Cardi's defense, rather. And so he is now arguing that they should have been, the court had the power to exclude. That sounds like it was discretionary. So if it was discretionary and the court already ruled on it, what you saying, like your discretion wasn't discretion enough, it wasn't discretionary? So he's saying those 2 witnesses should have been excluded. You said wait, so they lost and they can keep suing. How many times can they do this? They're not trying. So what happens is when you lose, you have different options that you can try to get another opinion, if you will. So this is a motion for a new trial. That's another one way to get it, and that goes to the trial court. You can appeal. You order all the transcripts, and once you get your transcripts, you find the issues and the error that you say of law, and you submit it to the Court of Appeals and how the Court of Appeals review it. So you have then, of course, if the Court of Appeals denied, if you're feeling froggy and you want to leap, you can go to the United States Supreme Court, who only hears a very small fraction of cases. If it's not an issue they feel like is that important, they don't even pay you. They pay you dust. So that's how it works. So no, you can't keep suing. This if she tried to rebring this lawsuit and for the same issue that was already tried by a jury, it would be dismissed. Race judicata, like it's a decision. It's already been a final judgment. It's already been a decision. There's issue preclusion because this issue has already been litigated. However, you do have different ways to try to challenge the verdict until you exhaust all your remedies that you have. Eventually, it'll be exhausted. I just don't understand how we don't have any money to do anything, but we're going to do all of this stuff. I don't, we want a whole new trial. That sounds expensive. And Dree said, old girl worked there and called the doctor's office to ask the receptionist to lie for her on the stand. That is an interesting point. Hey, Jay, that is a very interesting point because the receptionist did testify, I guess, even though she denied calling at all. The lady did work there, so that's a good point, Andrew, which means your client knew who the doctor was and knew who the receptionist was. So if that's the case, like, you know what I'm saying? Like, how are you saying this was all you? It's not like you don't have any obligations yourself. In fact, she probably could have got the names of everybody faster. That wasn't even Cardi B's regular doctor. She was there for the weekend, and that wasn't her regular doctor. She had some issues, and she went to go check on her baby with her first pregnancy. That was a good point, Andrew. Thank you so much. All right. So they say he had the power to exclude. Plaintiff was precluded from obtaining their depositions early on to cross-examine them. This could not be done at the time of trial. So you could have just noticed up their deposition. That's all they had to do. Your client, it seems like an initial intake would have been like, okay, so who is the doctor that was involved in all of this? Who is the receptionist who was involved in all of this? And they would have been the first ones off subpoena. So I don't think that's going to work. Plaintiff did not personally have the names of Dr. Fink and Miss Malcolm. Defendant did have the name of her own doctor and could have easily obtained the name of her own doctor's assistant. So could you, sir, because your client did work in the building. Allowing Dr. Fink and Miss Malcolm to testify at trial was a significant blow to plaintiff's case. It was. I agree. It just bolstered Cardi B. I mean, that's what it did. She didn't have anybody to corroborate what she was saying. These witnesses should not have been allowed to testify. Don't agree with that. So we're at the conclusion. Told you all it's a nice, easy read. All of these actions combined had an effect the outcome of this case. Plaintiff is entitled to a new trial under the circumstances. Plaintiff's counsel is limited in his ability to provide additional information at this time, as he is represented by counsel for defense counsel's wrongful conduct. Plaintiff's counsel nevertheless submits this motion for a new trial. This motion is based on the notice, the memorandum of points and authorities attached hereto, the declaration of attorney Ron A. Rosen-Jamfasa, all pleadings on file in this action, papers and records on file in this action, and upon such other oral and or documental evidence which may be properly before this court at the time of hearing of this matter. For this reason and the additional reasons set forth herein, it is requested that this honorable court grant plaintiff's request for a new trial. And so this is his declaration. If you guys, are interested, he says, I am an attorney at law, duly licensed to practice before all the courts in the state of California. I'm attorney of record for plaintiff Emani Ellis. Our personal knowledge of the facts set forth in the declaration, and if called as a witness, could and would testify competently to such facts under oath. Plaintiff Emani Ellis was assaulted and battered by defendant Belcalis Almanzar on February 24, 2018. The parties proceeded to trial before a jury of 12 people, which lasted from August 25th, 2025. We heard all of this in the beginning. I respectfully apply to this court for a new trial for multiple reasons, which affected the outcome of this trial. First, the trial misconduct by defense counsel, who should be held in contempt for his violations of the court orders and the California Rules of Professional Responsibility. So basically, cut and paste, put it on the number. Second, defense counsel also physically intervened when I was speaking with Dr. Fink on August 27th at the courthouse, which amounted to an assault and battery. Another cut and paste. So they basically cut and paste most of the stuff that was in this pleading and put it in this affidavit. And that's it. That is all. So they are hoping that they can have a hearing on this on December 5th is when they are requesting this hearing. And for this that's all I got, y'all. That's all I got. She is asking for a new trial. It is so contradictory to the previous document that I read where he said he just wants to move on with his life. This is stressing him out. He got anxiety. Cat Knott Williams said, I want to know if Jamfaza spoke with the journalist about the pen and the expert witness to hint they should press charges. I was kind of getting that too. I was like, do you guys, I was thinking the exact same thing. I was like, I wonder if they're trying to somehow get more people to come forward and do something about it. But we all know about what was going on with the pen incident. And I didn't hear about a person who got injured, like got pushed and fell. This is the first time I heard of that. So I didn't hear that one. But yeah. You said wants money and not going to get it. When you're a trial attorney, you win some, you lose some. I tell people when people hit their first loss, because you're on a high when you get your wins, you're not trying cases if you ain't losing any of them. I mean, yeah, there are some people that allege they got 100% record. I haven't met them yet, but I'm sure they're out there. You should always be winning more than you're losing. So for every one trial you lose, you should be winning the next 9. That's how I feel. But you learn more from your losses than you do your wins. So it empowers you to want to be better than your previous trial. And it just sounds like he's just not taking this loss very well. He just needs to take his licking and keep on ticking. I don't know. But let me real quick, because I kept bringing up his what his response for sanctions was when he objected. He said, it was real quick. He said, defendant obtained a defense verdict against plaintiff on September 2nd. Defendant made specific statements on September 2nd, 2025 to all of the news stations that the parties would be walking their separate ways when she left the courthouse. Plaintiff agreed to move on with the understanding that the entire case will be put to bed. How you agreeing to move on when you did a press conference and said you planned on appealing and now you're doing a whole motion for a new trial? So you're showing that maybe we shouldn't be listening to, rely on what you're reporting as well, because this doesn't even make sense. It's so contradictory, it's ridiculous. The issuance of an OSC, trial misconduct against the plaintiff, is extreme and inefficient. Contempt will require plaintiff's counsel's conduct to be willful, which it was not. Plaintiff's counsel is not a, quote, seasoned trial attorney and did not intentionally attempt to violate any court orders. Plaintiff's counsel apologizes in advance to this honorable court for any errors made during the course of the trial, which lasted from August 25th to September 2nd. Plaintiff's counsel was simply asking questions as best as he could in an effort to zealously advocate for a plaintiff. Plaintiff's counsel did not ask questions in an attempt to willfully violate any court order. Defense counsel goes on in an effort to paint a false picture of plaintiff's counsel by presenting a total of 25 counts. So I'm not going to read all of it, but I do want to say, okay, so this part. It is evident that defense counsel Peter Anderson has something personal against plaintiff's counsel. Plaintiff's counsel has lots of respect for this honorable court, has expressed that in his case and other cases. Plaintiff's counsel took this case on from another law firm for the sole reason of giving the plaintiff an opportunity to be heard. Plaintiff's counsel has already lost thousands of dollars in that pursuit, even though he is struggling financially. This is what you said to the court. But you want a whole new trial. Plaintiff counsel's law license is the most important thing to him, which he would never sacrifice for any reason. Plaintiff's counsel previously proceeded to trial in approximately 10 different cases in this career as an attorney. Plaintiff's counsel also served as co-counsel in several cases in his career. Plaintiff's counsel's future career path is to be a judge in an effort to help people by administering justice. And then he goes on about defense counsel threatening him several times about contacting the bar, and he got that as Exhibit 2. He says preparing a formal opposition to an OSC will require plaintiff's counsel to spend thousands of dollars, which he cannot afford at this time. Numerous hours will also need to be invested fighting this on a case that should be over. The honorable judge presiding over the entire trial, it would appear that this honorable court would not find plaintiff's counsel to be in willful violation. This case is giving plaintiff's counsel a significant amount of anxiety. Plaintiff's counsel respectfully asked this honorable court to give plaintiff's counsel the benefit of the doubt. Plaintiff lost the case and there was no prejudice to the defendant. This is what you just said on October 26th. And then by October 31st, you filing the motion for a new trial. So this is the exhibit that he says was the threat to the bar. So this was to Mr. Rosen, where they said, I write in response to the voicemail. This is from Peter Anderson. I write in response to the voicemail message you left for me at 8:47 a.m. today. First, as a general matter, I reiterate that as stated in my August 2nd, 2025 letter to you, and for the reasons stated in this letter, all communication between our office must be in writing. Do not attempt to call me or any of my colleagues, and instead confine your communications to email. Essentially, Mr. Anderson came to the conclusion that every time we talk, so you could be reminded of what the conversation actually really said, I'm going to need this to be in writing. So don't call me, which says a lot within itself, because we talk a lot. We talk on cell phones, we talk in courts, and the fact that he's like, no, I don't need no communication unless it's in writing. Second, I write specifically with respect to one aspect of your voicemail message this morning, namely your threat to hold a press conference about this lawsuit in the upcoming trial. So in the voicemail, according to Mr. Anderson, it was Mr. Jamfaza who said, I'm going to do a press conference before this. He could have took that as if you trying to pressure her to settle because you're about to blow this thing up. So everybody that hasn't been paying this case any attention will start paying it any attention. So then he says the California Rule of Professional Responsibility 3.6 bars lawyers from making extrajudicial statements that the lawyer knows or reasonably should know will be disseminated by means of public communication with the substantial likelihood of materially prejudicing a jury pool and jury trial. So he's reminding you of your professional responsibility obligation, because it's in response to your voicemail that you said you're going to hold a press conference about this lawsuit. Obviously, your threat to call a press conference about this case a week or less before trial is within that rule and prohibited. Since you also state that you have received inquiries from the press, I note that the same prohibition applies to you talking to the press. We reserve all rights, claims, and remedies, also including defamation, as any statements you may make to the press or others, and the right to advise the court of your threatened press conference. Where did he say, I'm threatening your license? That this is what the evidence was. That was the evidence that they attached. Apparently it was more, allegedly, but yeah. Talk about flip-flopping. This guy just wants a bag, in my opinion. Thank you for the super chat. I appreciate that. He said, including this email as proof of a threat is a wow. My thoughts exactly. That's all, y'all. That's all I got. I just wanted to give you guys the update. Thank you all so much for watching. Thank you so much, Kat Knott Williams, for coming over. If you guys aren't subscribed to her, make sure you go over there, subscribe to her channel. She's pretty dope. And yeah, thank you all for all the super chats. And I'm out of here, y'all. Gotta go. Make sure you like the video, subscribe to the channel, tell all your friends to tell their friends and all their friends about this channel. So, all right, y'all. I'm gonna holler at you next time. Gotta go.